Welcome to our tax planning webinar series, and thank you for joining us. It is about that time of the year, everyone's favorite, where we all start planning for year-end and preparing for the upcoming tax filing season. We've put our heads together and come up with the top tax planning topics this year and created a webinar series. In today's webinar, we are going to be talking about estate planning and its effects on taxes. My name is Caitlin Milloway at HHM CPAs, and I'm joined by two estate planning professionals. They will both give a different perspective on the matter from their two different industries, accounting and law. Could you two please introduce yourselves?
Sure. I'm Leanne Adams. I'm a Chattanooga native. I am an attorney at the Gerheiser Peters Elliott and Cannon law firm. I have been practicing there for almost 25 years, almost exclusively in the areas of estate planning and estate administration.
Thank you, Leanne. I'm Terry Jeter McAvoy, and I'm a senior tax manager at Henderson, Hutcherson, and McCullough. And I've been practicing in this area for a very long time, over 40 years now. And I am not a Chattanooga native. I was raised in the Air Force, so I have lived all over the country.
Awesome. So do you think we'll have a legislation in 2021 that includes changes to estate tax laws?
At this time, we do not believe that will occur. There will be some changes in the tax laws, but not major changes in the estate tax area, we believe. The House has passed legislation that the Senate, we hope, will be voting on this week. However, that legislation does not have substantial estate tax law changes. The current exemption amount is $11.7 million, which means that individuals can, at their death, give $11.7 million free of federal estate tax. In 2022, that exemption amount is going to increase to be a little bit over $12 million per person.
Awesome. So is estate planning only for the very wealthy?
No, estate planning is really for everyone. There are aspects of estate planning that affect me, my children, and everything I own. What I think of it as is the systematic planning for my personal and my financial affairs should something happen to me at my death, or even a major life occurrence that changes something, like a divorce or somebody getting married. There are certain situations that occur that make changes that are very important.
Awesome. So what do you think is a mistake that people make with their planning?
One mistake is that they do not loop in all their advisors. They have quality advisors like Terry here, but they don't bring her to the table when they are discussing estate planning. You know, your different advisors have different areas of expertise. They have different knowledge base, and the best plans are when you bring all those folks together so that they can look at the planning from all aspects. You know, a collaborative approach is the best approach, in my opinion.
Yeah, I find a lot of people that you speak with when we kind of go through an intake process when we get new clients, and one of the first ones is we ask for documents. Do you have wills? Do you have this? You know, who are your advisors? And I'm amazed sometimes how few people really have wills that are current within the last 3 or 4 years, how many of them have financial advisors, how many of them have looped everybody together. It's so important for all of us to work together to make the best plan for our clients.
You know, and another mistake people make, in somewhat the same vein, is they don't share information with these advisors. They either, for whatever reason, share incomplete information or inaccurate information. And even the best advisors cannot solve problems that they do not know about. That's just not possible. And so, you know, we encourage our clients, share the information. Good, bad, indifferent, share it with us. And that's the way to get the best plan.
And that's easy to do. All that a client has to do is notify the other advisor in writing that they're working with Leanne or myself, and to authorize them to give information to us. And then we can freely share information back and forth. And it makes the planning so much better.
Absolutely, for sure. So what are the most important estate planning instruments that an individual should have, especially during the COVID pandemic?
Well, you know, I believe that a durable general power of attorney is a key estate planning instrument that everyone needs, not just our senior clients, any client over age 18. And during the COVID pandemic, we certainly saw these being used more. A durable general power of attorney is a document where you name an individual or individuals to make financial decisions for you. If you're not able to, or if it's not convenient for you to. I know during COVID we had some clients who were, it was risky for them to be out and about in the public. But the agents that they had named under their power of attorney were younger, were healthier, didn't have underlying conditions. And so they were able to use that power of attorney to transact business for the clients and kind of keep the client, back at home where they needed to be. So, a power of attorney doesn't take away your rights to make financial decisions. All it does is add someone to that ability to make financial decisions.
And what's the difference when we say durable between durable and a non-durable power?
Oh, that's such a great question, Terry, because we still encounter this every once in a while. It seems counterintuitive, but under the common law, a power of attorney ceases to be effective once you become incapacitated, which is ironically exactly when you would want the power of attorney to be effective. So durable power of attorney means that it continues to be in force and in effect even if you become incapacitated, that your agent can still act under those circumstances.
Yeah, an additional document I personally feel is very important is your medical power or your advance directive for health care. This is another legal document where you name someone else to make decisions for you regarding health care if you're unable to make it for yourself. The reason these are so important, I feel, is you're telling the person what you would want. Do I want to have artificial feeding tubes? Do I want, my life prolonged as long as I can, even if it may not be quality of life? There are major decisions to be paid. And with COVID, very many people have gotten to the point they really aren't capable of making valid decisions.
Right, and one reason why we really push powers of attorney in our office is because the alternative to not having a financial power of attorney or a healthcare power of attorney can be a conservatorship, where the court supervises matters and the court names someone to make those decisions. And really the powers of attorney are an efficient, less expensive way to handle those issues.
Awesome, thank you. So what are some common misconceptions about wills?
One I still ran into last week, is that if you do not have a will, that your assets will automatically go to the state of Tennessee. That's not true. That won't happen. And the state of Tennessee and all other states have made a will for you. So if you do not have a will, there are Tennessee statutes which say where your assets will go, and usually it's where you would want them to go anyway: spouse, children, parents, siblings, kind of depending on your cast of characters. But I can tell you that it will not go to the state of Tennessee.
One of the things we find a lot happening is that people have a misconception that if I have a will and I have outlined in my will exactly who I want to receive everything, that's going to happen. And that may not be true. There are certain accounts you own that have what we call a named beneficiary, and that common one would be my IRA account. My IRA account, when I set it up, part of the setting up forms has me name beneficiary and alternate beneficiaries. At my death, then, that account is distributed to those people. It is irrespective of what my will says. So a lot of times when we're doing planning, this is again where we need all the advisors together, because we need to know accounts you have like that and who you're giving your property to. If you have that name, let's say I have my spouse named initially and then my spouse is not here at the time I die, and I've named the alternative to be 3 of my kids, 1 of my kids, it doesn't matter who, that's who's going to get the property regardless of what my will says.
Right. Part of our intake as well with clients is really, do you know how this asset is titled? If it's titled jointly with right of survivorship, then it will go to the surviving owner regardless of what your will says. Do you know who the beneficiaries are? I can draft a will that does exactly what a client wants, but if all their assets are controlled by beneficiary designations or joint ownership, then that is not going to occur. And I've had several incidences over my career where there's some heartbreak over that, and so we really try to push it and hope our clients remember, because that is sometimes it's right to begin with, but then clients drift away from it later or forget, what the will says, and they name beneficiaries instead, and it distorts their planning.
One of the other areas that we find a lot of misknowledge about is joint properties with rights of survivorship. Most married couples will create accounts, for example, put the house in both names, and what happens to that property when one of the spouses dies, the other one inherits it automatically. Again, this is outside the will, no matter what the will says, and you end up with people not understanding joint property. We have found it many times. We probably both have terrible stories about elderly people who have one child local and the other kids are moving. It's so easy to move now, and people are living all over the country, well, all over the world, to be honest. And we may have one child locally who's helping the parent, and next thing you know, all the accounts are in joint name with that child. Even though the parent's will would say, I want to divide all my property among my children, the joint property ownership trumps the will.
It does.
And you say, okay, that's fine. This child could just turn around and make it right, do what mom or dad wanted. That creates another set of problems, potentially.
It can, and I kind of tell clients sometimes, undoubtedly your child will want to do the right thing, will mean to do the right thing, but sometimes there are negative tax consequences from doing the right thing. Also, if that child has creditors at that time, creditors don't care that you are supposed to do the right thing with those assets. Those assets belong to that child. So there's just a lot of ways that can go south.
Right, and a way to make it not go south is what we talked about earlier, the durable power of attorney. Would allow a child to act for the parent at all times, and therefore, transact bank accounts and do different things that they want.
Yeah, without making it jointly owned.
Right.
Right.
Right. Well, thank you both for taking time to speak with us today about estate planning. It was very helpful. If there are any questions, please reach out to us at hhmcpas.com, and they'll be happy to help.